nuptial agreements include provisions for spousal maintenance or child maintenance in Latvia?
The question is short, the answer will be larger. Yes, of course, in the nuptial agreement, it is possible to include clauses and other aspects. Strictly speaking, the law says that nuptial agreement is only about the property relations. So the law does not say that nuptial agreements could include any other clauses, but the practice shows that, yes, at times the parties write also other things. It is not practical and it is not widely used. Why? Because all aspects related to children can change any time. And even if we provide that after divorce, the children will live at one place or the maintenance payments will be in the amount of one sum, that can always be changed because if the situation of the spouses or children are changing. So most of all, only classical, strict property-related agreements are chosen by the clients.
And for me, that's my understanding of how it is in Italy and many other jurisdictions. Is that the same for you, Diana?
Yes, it's very similar. Actually, yes, we may include any provisions regarding spousal maintenance or child maintenance, but there is a big difference. Because if it regards, or as long as they are not unlawful, they're not contrary to the custom or the principle of equality between the spouses. And yes, we may include agreements regarding child provision, child maintenance, or parental responsibility. They are valid, but they're not binding. I mean, you can agree what you want, but it does not oust the jurisdiction of the court. I mean, the judge has full powers. So they are not enforceable because the interest of the child is what's going to be taken into account at the time of the break of the marriage. As regards to spousal maintenance is different. I mean, I have seen, not very common, but sometimes I've seen it. I've seen really renounced to spousal maintenance. And the courts usually consider, I mean, they do consider these provisions valid, but they, as long as they do not renounce to the right of to receive maintenance, is not detrimental to one of the spouses. But what I have seen is that the courts, yes, they consider them valid, but maybe not binding, because the circumstances may have changed from the moment that they signed the agreement. So if the circumstances change, then they will not enforce that agreement. Because, I mean, the moment the circumstances are altered, then they don't take that into account.
Yeah, so they'll enforce the capital aspects of the agreement, but they'll interfere with the maintenance if it proves to be unfair.
Yes. No, not unfair. No, it's not so much if it's unfair. If it's the circumstances have altered, usually it has to do with being unfair. Let's say that usually it's the wife who's working and at the time of the marriage, but then she stops work. And then she looks after the family, she looks after the children. So at the time of the breakup of the marriage, she hasn't got to work, she does not have property, she has nothing. Then in that case, the courts will understand that the circumstances have been altered and therefore the maintenance agreement is not respected by the court.
Yeah, I think that probably would be the same in England. Would it be the same in British Columbia, Lisa?
Yeah. It sounds very similar to what a judge might do in British Columbia, what Diana was describing. On the issue of children, our agreements can't contain items. You cannot pre-decide what would happen with an agreement. And as I was listening to Diana and Dana's answers, I actually was thinking about whether or not a judge would quite unfavorably view if people had purported to put in those clauses. I had a bit of a curiosity as to whether that would raise suspicions about the rest of the agreement. Not in any technical way, but in a what else have you put in here sort of way. Pardon me?
Maybe manipulative or overpowering or something.
Well,
like
just a sense of, hey, if you've made all of your decisions, what didn't you take into account? I want to nuance this answer just a tiny little bit, because there's usually two situations where a prenuptial agreement is being put in place. One is for a second or more relationship where the parties already have their work life fairly settled and their assets fairly settled. It's more likely that if you waive spousal support under those sorts of circumstances, that you would be successful in maintaining that waiver later on, particularly if full disclosure had been made. Although with the caveat that Diana said, that if it functionally turns out to be unfair, a judge could choose to set that aside. But the other one that we see a lot of young couples where they're potentially inheriting family money, or that the parents or part of the extended family runs quite significant corporate assets that may have trusts that are flowing in and through. And so their corporate and estate planning may involve having these children as part of the trust, where dividends or payments need to come out, but the expectation is for them to come back into the family. And we do a lot of prenuptial agreements in those sorts of situations. So we have to walk quite carefully in terms of what income is included for the purposes of calculating spousal support, and what income is explicitly excluded.